designed with you guys in mind, and I think many of you probably from the conversations we've been having are probably just starting out on the GDPR journey. So what Richard's going to do today is present everything that you need to know so that you can get started with GDPR. We've done a quick workbook which should have been sort of flagged up when you first logged in to be able to download. It's literally just the main areas that Richard's going to run through and highlight today, just if you need some ordnance with regards to how you're taking your notes. We will be sending a recording out to you afterwards, so that if you want to revisit any parts, because there will be quite a lot of information, then you've got the opportunity there. And also, if you wanted to share that with your colleagues as well, that you can. Another thing that we've done, we've put a self-diagnostic help kind of document together. So this is really intended to complement what you're going to find out and sort of listen to today. But it will also start to sort of raise some questions about the current business processes and how they're aligning with GDPR, and potentially then what sort of actions you might need to take. Both the recording and this document we're going to send through by the end of the week. So by the end of tomorrow, really. So they get moving on that, Richard. The bottom line, though, is that we want to get our customers to be as informed as possible. And I think it's been branded around GDPR, sort of going around as a bit of a buzzword at the minute. But we want you guys to be as comfortable as possible with all the changes that are happening with data protection. I think the main priority is that when we get through to May 2018, we're not sat in panic mode. You guys get ahead of the game. Your recruitment data, you're confident, you're secure, because GDPR just affects so many elements of business, and recruitment is just a little small part of that. And if we can sort of take some of that headache away and panic away from you, then that's sort of what we intend to do. We take all our recruitment and data and security and candidates and everything very, very seriously. And you will have noticed that we did a massive upgrade to the Applicant Tracking System, which you use to sort of filter all the vacancies through. We've called him Mr. Fats. Hopefully that's sort of sticking. In August this was done, and it was done in line with our responsibilities to GDPR. Now, just like many advertisers, I'll make this point clear, we're simply the data controllers, and it's our responsibility is very, very different to someone who is actually processing that data, aka you guys. So what I hope this webinar will do, and the plan system updates that we've got in place, is going to demonstrate our commitment to you and sort of what we want to help you to achieve with regards to getting your strategy right and managing and processing all that candidate data. So there's a lot to get through, as Richard pointed out, and there's a lot of sort of stuff there, but we're trying to make this as practical as possible so that you will have some action points and actually get some sort of value out of what you want to do, what you need to do for the future. So, without further ado, Richard, I'm going to pass it over to you. If anybody's got any questions, please use that chat box as we're sort of going through it. And I'm sure Richard will run through sort of the format on that basis as well. So, thanks everybody. Speak to you at the end of the webinar.
Okay. Thanks, Liz. Liz mentioned the workbook. Now I've put that up, so you should be able to see this, and you should be able to download it. That will be in another box by the side. So if you select on that, you'll be able to sort of download it. It is a Word document, so you should be able to sort of type notes in there. But you might want to take notes as you go along. But so let us know. Type into the chat box if you need that. The document. Right, so GDPR, right. First things then, a little bit of housekeeping, just so you're aware. Hopefully the webinar should last about 40 minutes. They have previously, the ones I've run previously have gone on a little bit longer due to all the questions. If you type your questions into the box, into the chat box, I'll pick up as we go through. Webinar's being recorded, and the webinar will be shared. That recording will be shared with you, so you can revisit if you need. And obviously, those people have found the chat box. That's great. So, who am I? Well, basically, I've been in consumer finance, dealing with lots and lots of applications, so and having to handle people, lots of serious amounts of data. Moved into recruitment advertising back in 2004, and specialised in that. And then as part of that, we used to use proprietary software, and realised soon into it that it didn't actually work for us or our customers. So at that point in time, as you do, you get crazy moments, and decided to build my own. And in conjunction with customers, we built our first system, and we've gone on to build it and make it better for more people, and hopefully, so that, in that respect, in the 9 years of building software designed specifically for recruitment, that should hopefully sort of give me some sort of qualifications in that sort of area. Highlights for us over the last sort of 18 months, 2 years, really are the fact that we made our system then comply with the FCA guidelines. So we have customers with standalone systems, and then we look at what's going on, and we make sure that whatever we produce complies with that. And then obviously with GDPR, it's 18 months old now as GDPR, but obviously back in 2016 we set the roadmap out to make the necessary adjustments, and as Liz highlighted, we've rolled version 1 out this year, and because of the GDPR, we've got systems going out in the marketplace that actually have all the functionality on, but obviously because it's a group system, we can't enforce that sort of functionality across all of the people, so there's elements that are going to be updated. And we've also got a system that is an application form system that meets the CQC guidelines, particularly section 19 of that. So from a sort of a background in terms of software, one of the things we try to do is consistently, all of our customers provide us with the inspiration and the challenges, and then obviously we grab them and try to meet them. So hence the reason why we're doing this in terms of making the systems work for GDPR. So, right, GDPR, what do you need to do to make your recruitment process comply? Now, I'm just going to sort of put it down here in terms of a little disclaimer that the advice I'm going to give you is generic, because GDPR will affect each business, and it's the recruitment process. It will affect each business slightly differently. So I'm going to talk about the sort of the high part of it, give you pointers, some tips at the end, and so that you can actually see these things. But it's how you work is going to be, and how the changes that you need to make are going to be specific to each of your organisations. So, just to give me an indication, just in this particular, I'm going to open a poll up just so that I know how you're currently dealing with your application, so that I can then focus in and cover the certain areas that need. So I've just opened up a little poll there that should be on the right-hand side, and whilst you fill that in, I'll just sort of carry on. So what we're going to do, what we're going to cover. What we're going to cover is the background, the actual law, complying with the law, talent pools, security, and then obviously some tips. So the background, how did it get to this? Well, if you turn the clock back, marketing departments, when people were applying for things, for their finance or car insurance or basically anything, would have right at the very bottom some statements, and all the boxes were ticked. All your data, you would then submit that in, and then your data the company would use that. But then obviously companies then sold that off to other companies, and therefore you would then end up with all these cold callings going on, and obviously being bombarded. So this is one of the reasons why the decision was made to adopt the European rules and obviously bring that into place. Now, we can look at it in one of two ways. You've got the emotional side of things, which again hit the news yesterday. You have the emotional side of it, and the press are playing on that, which is the fines. Or we can look at it logically, and this is hopefully what the webinar is going to be about, and I'm going to take you through the logical side of things and using best practice. So that's what we're looking at. Right, let's have a look. So that's quite interesting that we've got 36% of people using email, 9% with a downloaded application form, 36% using an online system, and 14% using contact forms. Great. So that's the poll sorted. Fab. Great. So we've got excellent. That's really helpful. So just while this poll thing closes, let me just try to move on. So, just waiting for I can't move the slide. We're just waiting for the WebEx platform to do that for me. Right, thank you very much, WebEx. Right, so here is the law condensed down to one slide, and we've got an icon covering part of the bottom there. But the actual law I'm just going to pick out the key points of the law. The law applies to every piece of data that you receive, the subject data, so the personal information that you receive to people. So within that, it should be processed lawfully, fairly, and transparently. It needs to be collected for a specified and explicit purpose and not processed for anything else. A bit further down the slide into point number 5, it should be kept in a form that permits identification for no longer than is necessary, and it should be protected against unauthorized or unlawful processing, accidental loss, destruction, or damage. So that's the actual law as it stands. And I'm going to come back to that and refer back to some of this stuff as we go through the actual webinar. So let me just have a quick. Has anybody got problems with sound? So if we've got somebody there's still no sound, can you deal with that, Liz? Put them onto the voice platform for me. That'd be very useful. Right. So the first part is that we come back to dealing with this. We've got to process a person's data lawfully, and that refers us back to Section 6, and there's 6 ways that we can process somebody's data. And if it doesn't fit into this, then you can't process it. You're going to be breaking the law. But I'm pleased to tell you that in whichever way you take an application, you will be dealing with it lawfully. So we've obviously got the first where you've got consent of the data subject. And so for all those people here that have got people coming in via email or contact forms, this is then where we can deal with the fact that you're processing their data. So the main section there is 6.1b, and we've then got 6.1e and F. Now, the reason 6.1b is where most of our where we will legally drop into this, because it's the performance of a contract, and that contract is actually an employment contract. So that's how we fit into there. And then on F, where we're looking at 6.1F, that's where you're doing volume on. So this is where we're starting to look at these things, and you need to pick out the area that your business and organisation will drop into. And then in a certain case as well, 6.1E will apply, because in public sector, this is where we're looking at a task being carried out in the interest of the public. So we've got all you need to do is cover one particular area, and that's how you can then process people's applications even without their consent lawfully. So, but the point then is, this is the law. So if somebody hasn't sent you an application form or an email with a CV attached for a specific job, you're allowed to process it. And I come back to the point, which is for no long and for the purpose of processing, but you can't keep it for no longer than necessary. You've got to do it in a reasonable time frame, and then get rid of it effectively. So you'll comply with the law in that particular way. Now, the big part of what we really need to do is gain consent, because I'm sure there's people don't just want to sort of take all their applications and then delete them at the end of it. As people apply to the business, you might want to consider them for other jobs and other things, and that's why we need to gain consent of that person. So this is what we need to look at then. So, in terms of consent, if we can then get the slide to move, we then need to comply with the law and adhere to the rights of the data subject. So there's 8 areas that we have to do once we've got their data. Okay, we're specifically going to cover. I hope this slide's got bold on it. We're specifically going to cover the sections of 1, the right to be informed, 2, the right of access, and number 4, the right to erasure. I'm going to go across all of them, because what you've got to bear in mind, this is what they're here for. They're all 8 areas as things that we have to consider. But if you look at it from sort of a wider perspective across the organisation, GDPR affects us in all areas in terms of sales, marketing, accounts, even operationally, depends on the nature of your business. So each of these areas you have to then look at for each section, each particular part of within the business and where data is coming in. But from a recruitment perspective, we're going to look at those 3 areas, but I will touch on the other parts. So gaining consent, which is what we're actually wanting to do with everybody. So the bottom line on this is we need to inform people as regards to what we're going to do with their data as they're applying. So what we're looking at here is we need to be making a statement to people, advising them before they apply how you're going to process their application. How long? These are sort of key areas that we need to look at. How long are you going to store it? Are you going to use it for anything else? Particularly here, if you're going to look at it and you proactively work people across the organisation and you have a variety of jobs, somebody might apply for job A, but they might be suitable for job B. But if you haven't got consent to look at them and process them for job B, then that's potentially going to be an issue. So particularly if it's come in by email, you need their permission to consider them for something else, because you can only process them for that one specific job. So we need to ask them to obviously consent right at the very beginning to look for you to consider them for other jobs that they haven't applied for. If you're part of a larger organisation or a group of companies, and you would want to process look at their CV for any other opportunities across the business, you would need to cover that as well, because again, if they've applied to your company A, but there's company B, company C, and company C rings that person up to say, I'd like to talk to you about this particular job, that person may not know. And therefore, again, there's an issue there that's technically then a sort of a data breach. So we need their consent, and if they don't provide that consent, then obviously they can't be considered, because that's their option. Where and how their application is going to be stored, and then obviously what they have to do if they want to withdraw their consent at any particular point. So the main thing about it is this is where the consent side of it has to be explicit. It's not implied or assumed. So we can't turn around and assume that because on our statement that we're just going to, when we get it, we can do with that application what we want to do. This is where GDPR effectively drills down and says that we have to give people the options as regards to it. Well, this is why we can operate the way we are currently, but as of the 26th of May, we have to be doing this. So these are the things we need to consider. So your statement, which will include your GDPR statement, will include your privacy policy, but then there'll be lots of other things that you need to put into your GDPR statement, and these are the areas. Now, you could technically, if you wanted to, and I've seen this already, that you could actually put a statement out that covers everything, a generic statement that says we're going to process your application this way, we're going to store it for 2 years, we're going to consider you across all of our group companies, and the only thing you're allowed to do is click consent. I've seen that on some applicant tracking systems already. Well, that's actually not consent, really, is it? I mean, really, what we're turning around there saying is you've got to click consent or you can't apply. And we'll do with your data what we want to do. Yes, if we come back to the law, 6.1a is that you've actually got their consent to do it, but it's not really consent. You've made them do that. So realistically, and this was sort of advice and conversations that I had with the Information Commissioner's Office, best practice on this is seen to be able to offer at least 2 choices, because then that's a choice. And those choices could be simply, and there's areas that we're looking at, but there's 3 choices that we're using as a default one. Firstly, that they're giving that you make the statement as regards to how you're processing their application, and explain that, list that out. Secondly, we then turn around and say, would you like to be considered for any other vacancies? And then thirdly, it's about the consent for them to store their data. That's consent. They're being informed properly and they're being able to pick that up. Okay. So I just want to, while we deal with this, the right to be informed, just want to have a quick look. In my case, I send you a specification and CVs. Go to your portal, and then look at the CV and keep the ones that I may be interested in. Okay. Well, what we're looking at here is when the changes are made to the actual system, what will happen then is if people haven't provided consent, and you've at the end of that particular process at the end of that particular time, then and if they haven't provided consent, then the details will need to be removed, because we have to come back to is the fact that we can process them, but only for and keep the details, but only for as long as required, no longer than necessary. So once we fill that vacancy, it's no longer necessary to hold on to their data unless they consent to do that. Okay, so let's move on to the next part. I'll come back to some questions in a minute. The right of access. So, right of access is the fact that if the person supplied their information, we need to obviously confirm that we've got their data, and they should have access to that data. Now, they do anyway. There's no at the moment, if you think from a legal perspective, a person can have access to their information and the information that's held on their file. So all this is turning around saying that they still have that right to have access, and it's good practice anyway to send them a thank you email, just confirming whilst they've read the statement on the front and clicked and given you consent. It's always best to send a confirmation email to let them know that you have received their application and it's going to be dealt with, and that you're confirming the way that you're actually going to process that data. And this is, again, you add into your GDPR statement. And then the third point, before we I just drop back to the questions, is the right to erasure. Now, this shouldn't be confused with the right to be forgotten. People, obviously, if they withdraw their consent, which is effectively what we're talking about here, if people withdraw their consent, then you should remove their personal data, their data. So that essentially then is that all their CV or application form that they've sent through, the cover letter, and their address details. So the right you're still entitled to keep some data, and that realistically is their first name, surname, and email address, and that is from an audit trail perspective, because if that person applies to your organisation again in the future or in the past, you would need to then know in some respects whether you've seen that person before, or you may have interviewed them, and therefore you could go back to interview notes. If you've deleted all that information and you don't have that audit trail, and then you invite somebody in for interview that you interviewed 9 months ago, forgotten their name, they turn up, you recognise their face, you get some red faces, because you might then realise that they're not suitable from the previous interview. So this is why, in some respects, the system and within the FAT system is there, because you'll then know if people have applied to your organisation in the past. If they haven't given consent for the data to be stored, that's not an issue. That's dealt with by the system, but you still know that that person made an application and what the outcome was, whether it was unsuccessful or whether they were attended interview. So if you're using the system in the way it's meant to do, you'll be able to work them through the process and keep track of these sort of things. Now, the right to erasure, again, is withdrawing consent, and I'm going to come back to the talent pool and how this works in that respect in a second. So I'm just going to nip onto the chat just to have a look at some of the questions that we've got here. Tony's in there. So this is Tony. So Tony's got, I would look at them and then delete if not relevant, otherwise keep. Fine, but on that respect, that's great. If you're going to keep them, then you need to have their consent that you're going to keep them. So you need to deal with that at the front end. So if you're using contact forms, which is very, very difficult, you can't get consent off an email. So if the people are emailing that in, then and with their CV attached, that isn't consent. That's the fact that so you can lawfully process that application. But if you want to keep that person's details, then you then have to go email that person back to tell them that they're either successful or not, and ask them to keep their details on file. If you haven't got consent, then you have to delete it. So Tony's put there. Oh, crikey, the chat's moving. Right. Linda, reasonable time. Linda's asking the reasonable time you can legitimately keep an application after finishing the recruitment process. Good question, Linda. Reasonable time really is if you haven't got consent once you've finished processing. So if you've declined somebody, realistically that's at the point. So you're talking sort of days and weeks. You can't then keep it months. But obviously people will be in the recruitment, various stages of the recruitment process through to interview. So you can keep that information through the interview process and such like until you've actually then physically hired the person. And then at that point in time, realistically then at the end of that recruitment campaign, that you would then need to delete the data of the people that you haven't got consent of. In terms of people that do give you consent, then that's again something that you need to look at. A reasonable length of time, it could be 2 years. It depends on your sector. One of our clients will keep the data for people for 6 years, but that's because they're a specialist. The people that work for them have to have certain qualifications, and they have to have gone through certain areas. They're very hard to find in people, and they have a 6-month notice period. So their recruitment process is a lot slower. So therefore, they can keep people for a longer period. I was also asked by somebody about keeping data for 10 years. That's a bit excessive, but equally you could hold the data for 2 years and then annually ask them if they want to keep the data on file. But equally, that data would then be out of date, so they might need to look at it and update their information. So really, you've got to look at it from that perspective. It's what's going to suit your organisation. If it's fast-moving, you might only want to keep them for 6 months or 12 months. If it's medium and there's certain sectors that are skill shortages, you might want to keep them for 2 years. That's the sort of thing that you need to sort of consider and adapt to your business. And some of these things we need to come back to and look at this and create a method statement so that you're actually then demonstrating that you're fully aware of GDPR and that you're processing an application in this particular way. You're going to store people for if you haven't got consent for this amount of time after it's been closed, and if you're storing people's data, you're going to store it for X amount of time, and equally where that data is going to be stored. So I'll come on to that. Hope that helps there, Linda. Laura's asking I would inform them there are no vacancies, but ask for their permission to retain their details. Although guidance on how long I can keep this would be appreciated. Yeah, I mean, once you've got permission, as I was saying, you can keep them for as long as required there. That's obviously chat going on there. Let me have a look. If there's any more down in here. Emily has asked if we have an email with a CV attachment, do we need to delete this email? Yes. If you haven't got permission, yes. You need to delete the email and the CV and make sure that obviously that it's then not in your deleted items and the CV is removed from the temporary file. Reason behind that is security, which I'll come on to in a little while. Just because you've deleted it may not necessarily mean that it's deleted. So there we go. Richard's asking, is this GDPR retrospective? Does the need to gain consent apply to past applicants? Simply, no. It is not retrospective. The law comes into effect from the 26th of May, and then that's when you have to comply. If you have CVs in CV databases, the guidance has already stated that these do not need to be what's called repapered, which is repermissioned. It's basically we have to put our house in order and comply with the law from the 26th of May. So it's literally, we don't need to worry about it now. This is the whole reason for running this webinar. It's to get the thought process rolling about how we're going to deal with this as of the 26th of May, and actually start to look at the things that we need to do and make changes. Once we understand all these areas, and as I say, we're looking at it from a recruitment perspective. There's an element here in terms of HR. GDPR affects it then. the rights of the employees, and then there's other areas within organisation that needs to look at. So some of the other areas we need to consider, which is a nice way to move forward, which the areas really that we need to be aware of, but they don't really, may not really sort of apply. And loosely, I'm sort of going to try to sort of cover this. So as a data subject, as an individual, we have the right to have our data rectified. This really only applies if we've got the data in from somewhere else. And the only thing where I can look at that is if you had it in from a recruitment agency. Or so that if an applicant has submitted their details, generally we work on the premise that that person submitted the correct details. If they haven't and they want to update the details that they've submitted, then obviously one of the things we need to look at is their attention to detail skills. But from the right to rectification, this would only be if the data has been passed to us lawfully by an external source and that data is incorrect. That individual has a right to have their details corrected. So if an agency submits a CV and it's wrong, because it could affect the outcome of the application, maybe on dates of employment or something, the actual person has the right to rectify that data. The right to data portability, really, again, this is more aimed at things like, say, the financial services sector in terms of bank accounts. As an individual, we should have that right to have our files moved. So if we wanted to switch bank account, we shouldn't have to go through the process of having to go into the bank and give them all of the money laundering information as regards to passports and prove our address. Surely, if we were dealing with the bank, the Bank A, they'd have our details. Surely all they have to do is transfer the file because that Bank A should have followed the law, and that's where data portability comes in. So that's where we're looking at it there. Really, from a recruitment perspective, it's if it's where we've got a group of companies, the data portability then is to move that data from one company to another if they're using different systems. One of the next things we need to do as a data subject, we have the right to object. Now, I've put a little part on here that's basically the only reasons we have a right to object, and the rights sort of come into this part here about automated decision making. We have a right to object to the way our data is being processed, but realistically only if we're using artificial intelligence to make those decisions. So we can then turn around. So if we're using artificial intelligence to make the decision on whether we're going to offer somebody an interview, the person then has a right to object because that's artificial intelligence that's made the decision and not a person. Their details have not been reviewed properly, so therefore that person can object. And that's obviously dropped in here there are other areas in terms of things like credit scoring and what have you, but that's where, from a recruitment perspective, if you're not using automated intelligence, then people would very rarely object. And then obviously we have to tell people, as part of our GDPR statement, if we're going to be using automated decision making and profiling, and therefore that's then part of the thing that then they would obviously give consent to do. So that's sort of a whistle-stop tour of the areas that are loosely covered from that part. So let me just have a quick pop back to the chat. That's Richard. Emily, if personal information is on an email signature, does this email need to be deleted? Personal information really, it's to what extent. An email generally only has sort of your name and position. If there's more information, when we're talking of sort of personal information there, where people have put their address details in, then yeah, that potentially would need to be dealt with there. So yes, unless I'm reading it wrong, you would, generally speaking, an email won't need to be deleted. It's only the attachment, it's only the data that's attached to it. Annabelle, when somebody leaves the business and you move their files to Lever, so can you give references when required? Can we keep this now? Would we have to ask them if then a reference is requested? We just have to say, sorry, we have no information on them. Really, reference requests sort of drop into the HR side of it, because once they become an employee, GDPR sort of has a knock-on effect. Basically, laws aren't being changed This is just how we process the data and how we look after it. All existing laws. A webinar that I did sort of last week had education, and then there's some laws in there, sort of 1980, the Act of 1980. The GDPR does not supersede any law. It supplements that law, and it basically is how we then process that data and how we then store it. So in terms of references and giving references, and the law hasn't changed. Until the law changes from an HR perspective on giving references, there's nothing extra that we have to do. Annabelle says, I just still process leavers data, so that's fine. Okay, so yeah, we're into that's sort of into HR land, and I'm sure there's webinars around from an HR perspective that you need to be sort of looking at, and that does drop into that part. Unfortunately, I've sort of only focused on the point up until that person becomes an employee, because HR again is a sort of specialist sector, just like sort of the application process and how we look after data. Because of the, if you imagine that 200 people could apply for one job, and obviously only one person is going to get it, we're still, as an organisation, we're concerned about the other 199. From an HR perspective, they're only concerned about that one person. So talent pool, then, this is obviously the point number 5 was the right to restrict processing, which is one of the reasons why, as a personal opinion, we should be asking people whether they want to be stored in our database, rather than the assumption at the beginning in terms of a GDPR statement and saying to people that we're going to hold on to your data for 2 years. We should give that person the right to consent to their data to be stored. So, because this right here is our own individual sort of right to actually not allow that to happen. There's a lot of other areas within this in terms of the restriction of processing their actual data. Once we've processed this data, we want to then, in terms of talent pools, we want to use the system. We want to use this. We've spent money obtaining these people. We want to process them from something for other jobs within the organisation. Therefore, that's what we want to do, but the actual individual may not want to do that. So they have a right to actually turn around and say, no, I don't want you to do that. So that's what we should be able to do. They should have the right to block us from doing it. And as an individual, if you think about it from your own perspective as an individual, then you should be able to select what companies are doing with your data. So that's all we're doing. Best practice is let's offer them the opportunity to do that. Right, let's have a look now at one of the big areas, security and governance. Well, we couldn't have timed it better, could we, for a webinar? Obviously, within the last 48 hours, with hitting the news, Uber, controversially, have covered up the fact that they lost control of data. I don't know if you're aware of it, it's 57 million records across the world. So obviously there's going to be a lot of implications as regards to that. So this is where one of the key areas really from GDPR, not only about telling individuals about how you process their data, but obviously part of the law, coming back to that, is the fact that we should protect that data against unauthorized and unlawful processing, accidental loss, destruction or damage. This is one of the key areas because this is what we have to look at. So what we need to do is you need to demonstrate that your business complies, and you need to implement appropriate technical and organisational measures to do that. So you've got to, in terms of the process, in terms of your method statement, as regards to how you process things, you've got to document it. If you've got an I put on here appoint a data protection officer. Now, again, guidance has changed from when it originally came out 18 months ago. Originally, they were turning around saying organisations above 200 staff should have a data protection officer. Well, really now the guidance is more on how much data you're processing. You could be a small organisation with 50 or 100 staff and processing huge amounts of data. That not only just about in terms of in terms of applications for jobs, you might only have 5 jobs a year, but you might be processing client records and patient records and all sorts of things. So realistically, they've now turned around and said, actually, as every organisation needs to have people aware. And so data protection officers should be appointed within an organisation that has lots and lots of data, because you have to consider how this data is stored and accessed as well. In terms of employees, when we're looking at this as well from a processing perspective, if you've got more than 250 employees, again, the guidance is that you've got to maintain additional records about how you're processing that data. So an applicant tracking system, it's like an audit trail. So what's actually happening with it, so that you can actually sort of turn around and say that this is actually what's happening to all these people. If you're processing 10,000, if you have 10,000 people applying to your organisation a year, then yes, you do need to have some methods in place that can actually then demonstrate and have an audit trail for your own benefit as well, in case somebody turns around and wants to complain. And obviously less than 250 employees, and we're looking at smaller amounts of data. So therefore, we're not turning around saying, well, the audit trail doesn't need to be as extensive. But what we actually have to do is, if we're processing data, personal data that's got more information in it, and there's a risk to the person's freedom and sort of access there, then we've got to be very mindful of how we are doing that, and we've got to keep tabs of what we're doing with that. So, I'm just using this part here of turning around and saying criminal convictions and offences. If you're storing that and you're asking that, and it's on a paper application form or on somebody's email, and they've actually declared that they do have a criminal conviction, then you have a right, as an organisation, you have to ensure that data doesn't fall into anybody's into the public domain, because obviously it's very, very sensitive, and there's other areas of sensitive data. And again, as I was saying about your organisation and looking specifically at the law, because care is one particular sector, and then there'll be sectors that deal with the police and fire services and the information. If you have to gather specific information over and above that we would normally take to process an application, that drops into this category. And whilst you may be gathering that information, you have to document how you're going to treat it, and make sure that it's being processed, and make sure it's being stored properly. It's not a case then of keeping an extra log in an extra place, of turning around saying, right, well, this person's declared it and I'm going to put it on an Excel spreadsheet. Now it's in 2 places. So it's very much a case of then turning around, making sure that it's only there for, and that information is stored and only accessible in certain ways. I mean, again, there was a case probably around about a month ago where somebody working in a hospital in Warwickshire accessed the records of 38 people that she knew were either the medical records of 38 people that were known to her, either friends from school or family. Now, she broke the law, because obviously she accessed that, and there's an individual, the Information Commissioner's Office prosecuted her, and she was fined £1,000. And obviously she lost her job as well, because that's considered, it is gross misconduct. But as an organisation, when you have that data, you then have to make sure that only the people that should have access to that information have access to it, and that it's not available to everybody in the office. So you have to make sure that you have different layers, so that people that only the key people, the people that matter for that particular moment, have access to it, and that it can't be accessed later on. And then one of the other parts then is what's considered a data breach. What is a data breach? Well, there you go. The definition now is the breach of security leading to the destruction, loss, alteration, unauthorized disclosure, or access to personal data. Whereas previously, under the Data Protection Act, it was all about sort of data loss. This now is wider and covers a lot more, and the emphasis now is on organisations to notify the Information Commissioner if something happens. So, again, if you cast your mind back, sort of in maybe a year ago, we've heard instances where, particularly from within the public sector, somebody left a data stick on a train or lost their laptop. These are the things that's where organisations were prosecuted in the past. People could have gained access to websites and get data off the back of it, but sometimes whilst we might have realised our website got hacked, the actual sort of damage that was done by that was really never a case of then having to report that to the Information Commissioner. Well, if you're processing applications via your website and you're using a contact form, you then have to make sure that the data that you've got going through your website doesn't then still have, say, the CV attached. Or if it's a contact form, that information goes into a database. So that it might come through to you as an email. You'll process that email and delete it, but your website still might hold the data. So if your website gets hacked, you have to tell the Information Commissioner, because there's potentially the fact that they've got access to the actual database. The emphasis is on the organisation to keep control of that data. There was, again, in terms of guidance, there was this has sort of been sort of redacted. It's not there now in the latest guidance, but originally there was a case that the data needed to be stored in what's called the EEA, the European Economic Area. But obviously, I think as they've gone through, they've realised now that certainly with globalisation, that's a little bit more. That's a lot harder to do. So things because of just if we're using Office 365, for example, Microsoft. Well, the emphasis then is on Microsoft with regards to where they store, where their servers are. Because it's Microsoft, there's areas here that are outside of your control. If you're part of a global organisation, well, they might be using an American-based system, and therefore the data will naturally be stored in America. So they can't turn around and tell you where you can store it. Just a case of that you have to make sure that whatever you're doing, that you have to you've got to know what's going on in terms of where things are. So here we go. So that's the sort of security and governance. I don't know if there's any questions as regards to that. I'm just going to start to sort of go through some top tips for you now. I've got 3 of them. So this is to sort of try to help you, point you in the right direction. So tip number 1 is about getting consent. Let's not wait until 26th of May and then realise and then panic. Obviously, the reasons why you're here is obviously to understand a little bit more, and then try to start the journey towards complying. So, why not start writing your GDPR statement? That's obviously then and working out what that is. I mean, there's information around, and if you can gain this from the Information Commissioner's office, and we've and Flat Fee Recruiters putting its own consent GDPR statement together for when it rolls it out onto the system. So there's some guidance that potentially can be done there. But start focusing and thinking about the areas. What do you actually put on? How do you? Then this is one of the key parts. Let's start thinking about the way you actually review and you process an application, because that's the sort of information you're going to need to put into the statement. Whilst the generic side of things in terms of privacy statements are fine, and how to withdraw consent, how you process an application is specific to you and your organisation. So start documenting that. How do you shortlist people? Who else is going to see this information within your company? Look at your current application process, and actually, and it might, whilst you're doing that, it might give you the opportunity to change the way you're doing your process and revise it. It might be and streamline it. You might be doing it in a number of different ways, and obviously this GDPR, it gives you the perfect opportunity to make some changes to the way you're going to do that. And obviously change isn't easy to do, and obviously you've got to plan that change. So it is an opportunity to make some changes within your organisation if you feel that's appropriate. Bear in mind, people are going to have to consent to your GDPR statement for you to keep them. So, in that respect, write it from your own perspective as well. And consider it in that particular way. What do you consider reasonable in that respect? Rather than turning around and saying, "Oh, we're going to hold on to your personal details for 6 years," is that reasonable for your organisation? The type of jobs that you would have in your company. So, just look at it from that sort of perspective. Top tip number 2, if we can move on to the slide. There we go. Plan for the worst. what you have to bear in mind is it's never the masses of people that complain. It's just the one disgruntled person. There was a case recently, probably in the last 6 months, where one particular company advertised for a job, and the company got something like 30 CVs, and they interviewed a couple of people. And they hired one person, and then his friend in a different company was hiring for a very similar type of job. So what he did was he sent the 29 people over to his friend, and then that person then rang up half a dozen people to turn around and say, "I've got a job. Would you like to come for an interview?" And obviously one of them has then complained to the Information Commissioner because they never applied to that company, and that particular company was taken to court and fined, because they shouldn't have had the data. Both of the companies were fined. It's the one disgruntled person that's going to create your issue. So just think about that from the case of, well, if something does happen and there is a breach, or something does go wrong and somebody complains, what's that going to look like? And they're going to come in and they're going to want to see how everything works. Make sure that everyone that touches the application within your organisation understands their obligations, because again, think about the fact that if one of those people shares that data outside and accesses data that they shouldn't be seeing, and then it is discovered, that not only could they lose their job because it would be classed as gross misconduct, then that could mean that they get taken to court and fined. So each person that touches it needs to understand what their obligations are. So there's an education piece in there. If you've got an applicant tracking system, make sure that you've got your processes mapped out and documented so you understand exactly what it's going to look like. And whilst you're doing all this sort of stuff, just have a look at where you think that data could be leaked. Where if it was like you want to have a bowl, not a colander. So what you actually want to do is look at that and see where any potential thing could happen. How many different people are touching an application? If it's done by email, for example, if you're doing everything by email and you forward your CVs on and to a manager to review, even if you've got the best process in the world and a tracking system in place, and that you're using and forwarding the emails onto applications over to people, to managers by email, that's a data leak. Because if somebody comes along and it's never an email account, it's phishing scams where people then lose control of their PC. Well, that's where somebody could actually hack an email box. They don't hack a server, they hack an individual person. One particular PC loses control. Very rarely is it a server that ever happens. And because of that one particular person, if their emails are intercepted, there's a data leak. So you've got to look at these areas and just examine, because until you've actually started to find these things, you can't sort of move forward. And the final thing then is to know where everything is. Where is your email server? So look at your process, how things are working. If things are coming in by email, where is it? Where is that stored? Which company are you using? And then GDPR means that you need to have a contract with and know what's going on with your suppliers. So you need to have a contract with that. No longer can you you can just have sort of an agreement. If you haven't got a contract for it, then you need to read that contract. So you can see from that perspective, just like an employment contract, you're turning around to somebody saying these are your rights and these are my rights. Well, it's exactly the same as a supplier. So where is your email server? Where is your web server? What are their disaster recovery plans? If you've got an ATS, where are the data centers? What's there? What does this all look like? This is planning for the worst. Know where everything is, and then you can then start to plan and move things forward. Because if you know where everything is, it's like it's sort of into the business planning, isn't it? You need to know as it is today, and then we need to look at what the vision, and then we put our stepping stones in place. So until you know as is, you can't move forward. You can have a vision, but you need to know where you stand now. Get all these things in place, then you're beginning the process, the planning process, and moving forward, so that you can actually start to do these things and start to take action and get everything ready. So that covers sort of the majority of things, as I say, from a generic basis. Let me just have a quick look down. Right, let's have a look at cover these things. Where were we in terms of questions? So process leads. Right, Linda, I think this is where we've picked up. How can you display your GDPR statement if you are advertising on a third-party website, say a job board? Right, interesting. Liz mentioned this slightly earlier. job boards are data controllers. We're data controller. You're the processor. It's only on the processor to do that. So if you're advertising a job on anywhere, well, you then need to look at the process in that respect. So you have two ways. You can still accept that CV in by email, but then you're working on the lawful basis that you're going to process it. And then, so they're not going to read your GDPR statement. They're not going to have the opportunity to do that. So unless you change that process and direct them to somewhere, then asks that and presents that statement before they start applying. And this is what's going to happen on the FATS system. That there's all sorts of different ways you can look at that. An email can come in onto the FATS system, and a person will then receive an email where they then have to log in, and as they log in, they see the GDPR statement. So there's interaction going on here. But if you haven't got anything like that happening, that's why you're legally entitled to process their application if you're not able to present your GDPR statement. Best practices allow it. So, but not only would you be putting it on an external source, but you'd be putting it on your own website potentially. So if you're putting it on your website, then as people click apply, normally that's just a little contact form or an email address. If it's a submit button, well, in that respect, all you need to do is have sort of a screen or another page that pops up that then displays that information with a couple of options as regards to consent, and then they click submit and it comes in. But you need to look at how you're going to store that and consent. Work out how you're going to record their consent. The FAT system's going to do that for you, but it's not going to. This is one of the reasons why I'm saying about looking at your process, sort of internally about how you process, but equally then you've got a process then about how you generate applications. So that's a separate process because look at how you generate them, so that then you can then sort of look at how you're going to present and at what point you're going to present your GDPR statement. If I'm contacted by a recruitment agency, Beth's saying, and I am not interested in moving jobs, how would I ask them to remove my detailed CV without sounding rude? That's an interesting question, Beth. Again, GDPR affects recruitment agencies slightly differently. They've been governed, or I don't know whether it's a self-practice or whether there's a law, but they have to have that applicants put their candidates' consent to supply to you. So there's two areas here. If an agency is supplying people to an organisation, you as an individual candidate should give consent to that agency to supply that, and then that agency needs to supply that consent onwards so that you know that they've got it. That agency has got consent from that person to submit their candidates to you. And as a candidate, if you don't consent for them to store your details, then they have to remove it. It's as simple as that. Now, interesting. As a candidate, if you're how have they obtained your information is the next part. How have they got it? Because and that's just a case of how have they found it. If it's a CV on a CV database, then obviously that's something that you'll need to go and rectify as an individual. So in that respect, if the CV databases are used, that's where you would remove it. LinkedIn is a different scenario because headhunting is a completely different environment, and obviously GDPR. If you're putting your and so LinkedIn, we're going to have to watch what goes on with LinkedIn in this respect. But the fact that you're using something like LinkedIn means that you're putting your information out into the public domain. So if you're putting your information out into the public domain and people contact you, well, that's something that you've got to look at. But this is sort of going off on one side part to it about because even if you're doing that, if you're trying to find people for your jobs, and you're not just that's part of the way you work as well, and you use CV databases and things like that. If you're taking CVs off job boards, you've got to stop because you can look at them, but you've got to contact them. And if you haven't got the consent to do that, then you can't keep it. So it affects us all there. Beth, I hope I answered that one, Beth. Another one here from Beth. Same one. Let's move down. So Beth says, I don't want to risk burning bridges in case I do want their help in the future. Well, in that case, then you just have to sort of allow it to stay. Tony says, excuse my ignorance, what is an ATS? Not a problem. Lots of people are totally unaware of what an ATS. ATS stands for Applicant Tracking System, and that essentially is the starting point from when you create your vacancy, and then people apply via a web portal. They'll apply for the vacancy. And then you'll work them through the process using the portal, and then instead of using email and inboxes and files on your computer, the ATS stores all that information, so that then obviously it's kept secure and private. Only people that are allowed to have access to that, and that's obviously recruiting and hiring managers, line managers. They're able to keep it away from their inbox, communicate with people, communicate with job seekers so that they know what's going on, decline them. It keeps your brand reputation going on because you're doing these things seamlessly, and that's what essentially it is. It allows you to process lots of people and keep track of what's going on right now, and obviously for the future, if they apply again, then you'll know that they applied previously. So there we go. Hope that answers that one. Sarah has got put on here. Swear. Okay, there you go. Sarah's answered it as well. Sorry, I need to catch up with the chat, don't I? Sorry about this. Corrine says, where can I download this seminar? I think it will be made available. I think Liz will share it out later. Tara's got, should your GDPR statement be a fully inclusive for all departments, or do you need one for recruitment, human resources, marketing? Yep, GDPR means you have to have a statement for all areas, because each time something's happening, your GDPR statement needs to be tailored to that particular part. So if it's from a marketing side of it, then the marketing department need to look at how they get the data in and what they're going to do with it, and then they may have to make a statement for that as well. So it's how the data coming into your organisation. You need to examine that and look at it from that perspective. Calvin's got, if we have, for example, a copy of written warnings or dismissal letters for staff that have left, should these be deleted? HR-related question again. That's something that if you use an HR software, that they sort of would deal with that, and best practice from that side. I wouldn't like to comment really. Again, each organisation is different, and legal obligations are different for different companies, whether you're public sector or private. Laura's got, as a company, when we advertise on job boards, the adverts direct them to a point of contact within our business, either by email or by phone. At what point during the process do you think we as a business should be providing applicants with the GDPR statement? That's something that you've got to review. The phone one's an interesting particular part. If people want to apply, then obviously the GDPR statement, you'll probably have to record your conversations and the GDPR statement, and essentially you'll be having somebody filling out the application form on that person's behalf. So they'd be reading out the statements, and then that person would either say yes, I consent, and no, I don't. But the interesting part would there be, I would turn around and say you'd need call recording software from a phone's perspective, so that you're then covered from a phone application. And if by email, well, again, as we've just discussed, you need to look at that because you've only got the lawful basis to process their application. So, there's areas that this forms part of your review, your diagnostics. You need to look at these sort of things and say, right, okay, if it's phone, it's this. If it's email, email this, and maybe then that's where you then start to look at the effects that it's going to have on your organisation. Tony says, if we have job advertised on FFR ATS, do I need to do anything for GDPR? I think obviously Sarah and Liz will come back to you on that. But so yeah, I mean, I think that's all the questions. I think I've covered everything there. So yeah, I hope you found all that useful, and